We are here with Doug Baruch, who is a partner at Morgan Lewis, and we are talking about medical necessity. So Doug, we have a panel at this year's False Claims Act conference at the FBA on medical necessity. Give us a sense of, what medical necessity is under the False Claims Act and why it matters to folks who practice under the False Claims Act.
Well, I don't think anybody wants to be subjected to potential allegations of fraud or wrongdoing based on disagreements over clinical judgments. And that's really where the False Claims Act was going before the AseraCare case came down.
So AseraCare is out of the 11th Circuit. Of course, it includes Florida in the 11th Circuit. So let's talk about medical necessity in the wake of the AseraCare case. Does it apply beyond hospice, as an example?
Sure. So it certainly can apply beyond hospice. The question in AseraCare was whether mere clinical disagreements among physicians can be the bases for establishing falsity under the False Claims Act.
So in the wake of AseraCare, now what's the landscape? In order to have a claim under the False Claims Act, what would a relator need to have in order to meet that standard?
Sure. In addition to all the other elements, just focusing on falsity itself, there has to be some objective evidence of falsity. It can't be merely based on a disagreement among experts as to a government expert or an expert hired by a relator's counsel claiming that the physician or the provider got it wrong. That's not going to be enough, coming in after the fact and making that type of assessment. There has to be some other indicia of falsity.
So what would those indicia be?
Well, I mean, the traditional elements of some kind of misconduct, such as a false certification. The physician certified that a patient was eligible for some type of treatment, but never examined the patient. That would be indicia, right? Even if the patient actually was eligible for and actually had the diagnosis that ultimately the physician provided, if the physician never examined the patient, that could be a basis for claiming that there was a false claim.
So talk to us a little bit about the panel, maybe what folks in the audience might expect to hear from you on the subject of medical necessity, in particular kind of where that aspect of the False Claims Act is going in the future.
Sure. I myself will be interested in hearing from the government what their perspective is on it and what Relators Council are doing about it. But essentially, I think it puts the panel's going to be talking about whether, in the wake of AseraCare, there's going to need to be more than simply an after-the-fact cold record review with an expert to determine whether there's indicia of False Claims Act violations. They're going to have something more, even at the time of the complaint being filed. There has to be some other evidence of fraud, and not simply corporate policies that are focused on improving patient the census and those sorts of things, and improving billing and things like that. There has to be some other evidence that the judgment of the physician that a patient had the medical necessity that the physician attested to was wrong.
Got it. So give us a sense of maybe the kind of advice broadly that you're giving to your clients right now as it relates to medical necessity in the wake of the AseraCare case.
Well, I think the AseraCare case obviously was something that is beneficial because it does limit the reach within the 11th Circuit. Certainly, I don't think anybody's all that comfortable yet because it's just one case that's out there. It's certainly an important decision and a decision, in my view, in the right direction, but it's not something that providers can be comfortable knowing that across the board, across their nationwide and companies across their nationwide network, that the AseraCare case is going to insulate them from liability for the same types of allegations that were raised in AseraCare.
Doug, thank you.
Sure thing.
We look forward to seeing you at this year's False Claims Act Conference, February 27th and 28th here in Washington. You can find us and register at fedbar.org.